Okay, thank you very much, Liz, and thank you to the Wisconsin League of Municipalities or the League of Wisconsin Municipalities. My name is Stephen Aquario, and I serve in the environmental department as well as the local government department of Napoli Shkolnik. With us here today is Paul Napoli, one of our partners, who is very actively litigating the PFAS contamination, as well as a long history in environmental water contamination. And his work has been going on for several decades in water contamination, representing local governments. Coral Odiat Rivera is also with us here today. And we can answer questions on the chat line as we go through the process. We encourage you to use that chat line as Liz was doing earlier on, asking questions. That's the best way for folks to put questions in. And if we cannot get those answers today, we will work with the league to get those questions answered and returned back to the league so that they can share with the participants that are with us here today. We have several other lawyers that are part of the environmental team. Andrew Kroner is also part of the team, as well as Veronica Vasquez, and I did want to recognize them and thank them. We have extensive work also in opioid litigation and litigating against very large manufacturers, distributors in the opioid contamination lawsuit. But today, we all know, and we were all most scared of on Halloween, is PFAS. So we're going to talk about working to fight environmental contamination on Halloween. In particular, we're talking about two settlements that have recently occurred between 3M and DuPont with local government water systems, or as I call them, public water systems, PWS. So let's go and get right at it here. Our first chart, talking about the everywhere and forever chemical. And I think if we pause for a minute and think about where do those two terms, and we put those terms on there for a reason, everywhere and forever. What we now know is PFAS is basically all over the globe. It is affecting countries all around the world. But of course, we're talking about the United States right now. And so we're seeing the sources here of PFAS, or not sources, but just explaining what the chemicals are made of. These are man-made chemicals, includes PFOA, PFOS, PFNA, and Gen-X. Gen-X is the replacement chemical for PFOS. In particular, if you look at that bottom piece there, firefighting foams, the firefighting foams in AFFF, that's what we're largely going to be talking about here today, is litigation involving firefighting foams. But it's important to see how pervasive it is in cosmetics. You see states banning the use of PFAS in cosmetics, in pesticides, in nonstick cookware. You think Teflon, and some of the other food wrappers, the food wrappers of pizza boxes that were thrown into the landfill. And again, after it goes through a water treatment process, a biosolid is then created, and then the biosolid is yet again used on agriculture land, farming land, and then animals are ingesting that, and this cycle continues. So this is the everywhere and forever chemical, named forever because it does not biodegrade in any short period of time. It is around for decades, completely miscible in groundwater and water, and moves and migrates all over the place. Next slide. It's not really an emerging contaminant either. It's called an emerging contaminant on that first slide, but it's really been an environment for decades. What's happened here now is the science has caught up to it, and now we're able to detect and measure PFAS presence. So that's why we're able to understand more about PFAS. That's what's being talked about more now, is because science can understand it. Science has caught up to be able to test it at the level of 4 parts per trillion. This slide, again, talking about the everywhere and forever chemical that we were discussing here, the United States Geological System, or survey rather, recently about half of the tap water in the United States, half, 45% of the tap water contains at least one detectable PFAS. So it's a no wonder that we're all concerned about this on Halloween, and that is because many of us are ingesting tap water or potable water with a certain amount of PFAS in it. In that same geological survey, the United States reported that almost 8% of public water systems tested under UCMR 5 found PFOS at levels above the proposed MCL of 4 parts per trillion. So almost 10% of the tap water that was surveyed had these two contaminants, PFOS, PFOA. The United States is really focusing in on this. A lot of states have chose to regulate the field. I believe Wisconsin is still at a health advisory at 75 parts per trillion, but the United States moving incredibly quickly for a unit of government that large to move that quickly between a 75 part per trillion health advisory to an actual enforceable maximum contaminant level of 4 parts per trillion. And we'll talk about that in another minute. Next slide. So where are the sources? How did this happen? Why are we talking about this today? The sources are from our research, from our depositions, from our discovery and talking to manufacturers, from scientists and talking about this and litigating this for years and years and years, is the Department of Defense and any military institution, National Guard, depot, thick ammunition bases, anywhere where National Guard or Air Force would be training with firefighting foam. This firefighting foam was incredibly effective on extinguishing fires, repels oil, and it's just was used all over the military installation. So a lot of military bases are discovering this, and then of course leaching in and hitting the municipal water systems on or around those military bases. Manufacturing, of course, facilities that use PFAS in their manufacturing process. Landfills, where we're talking about those pizza boxes or really all the products, Scotchgard couches that were made over the years, all sprayed with these contaminants, were thrown into landfills. And again, number 4, and again, on the landfills, states like New York and others are beginning to put in regulations now around landfills to avoid leaching, PFAS leaching around landfills. The state of New York surveyed and tested all active and inactive landfills, and there were thousands of them. So Department of Defense, manufacturing, landfills, airport use at your Part 139 airports, again, mandatory spraying of this firefighting foam. That, of course, went down to stormwater runoffs and then hit perhaps municipal water systems like in Dane County. Fire training centers, number 5, fire training centers, volunteer firefighter, paid firefighters used and sprayed this firefighting foam. And so that's where we're, and again, water systems on or around fire training centers had DTECs, refineries that may have used AFFF as well. So those are largely the sources of where we found this and around the United States, and the fact pattern is fairly the same from one area to another area. If we know that that is there, it's the same fact pattern that we have been discovering. And by the way, this is not a sales webinar in any way. This is a court-required informational session. The court that is handling this is asking the attorneys that are involved in this to explain to the public all around the United States these 2 settlements. So that's what we're actually doing here today. So this slide, talking about US EPA. Everyone's aware of the potential health risks associated with the exposure to PFAS, and the United States has been very public now about PFAS being an urgent public health issue. Again, it's not an emerging contaminant anymore. It's just science is caught up with it. PFAS is estimated to be in the blood of almost all of us around the United States. I actually asked my doctor if he would test me for that as part of my blood work, and he would not do that. So I'd have to pay for that on my own to get the screening. But a lot of estimates have nearly all of us with some degree of PFAS. If half of us are ingesting it in public water from our taps, then through no fault of our own, it's in our bloodstream, and that's what that slide is talking about. And that's why the United States is acting and putting in place an MCL. The next slide is talking about what is the United States doing about this. Why are they doing it? What are they doing it? Given their position now, they are now in possession of human health tests. When the 70 parts per trillion was put out as a health advisory, the United States had animal health tests. There's now human health tests that have been done with testing for PFAS. And now that's why the United States is moving on putting in place a maximum contaminant level for both PFOA and PFOS of 4 parts per trillion, which will affect the Wisconsin municipal water systems. It's presently expected that the current proposed MCLs will be adopted at the end of this year. And once adopted, the water system would have 3 years to come into compliance. I want to just mention here quickly that this is the first contaminant in the history of the United States that is measured in a part per trillion. And many of you that are in the water business right now would know that it's usually measured in a part per billion or a part per million. This is a minuscule detect. We're talking parts per trillion. And for PFAS, the goal for PFOA and PFOS, the actual goal of the United States, if you go back and read the regulations, their goal was not 4 parts per trillion. Their goal is 0 parts per trillion. There should be 0 parts per trillion in your drinking water. And that's the goal of the United States. But they have no way of detecting it below 4 parts per trillion. So that's where they're focusing in on now, of setting a 4 part per trillion MCL. The estimated cost of compliance, the good news, if there is any good news or silver lining here, is science has caught up with the detect, and we are able, the good news is for our public water systems, we are able to remove the PFAS from our drinking water through GAC filtration systems or reverse osmosis. We have technologies that can remove it. And cities like Wausau, that's in the middle of all this right now, have been doing this for quite some time. It can be removed. The bad news, it can be expensive. Here, this slide showing at the bottom there, the United States annual cost for the public water systems across the United States, somewhere around $1 billion to address the compliance with the MCLs or removing PFAS from our public water systems. It's a capital expense. Think about treatment plants, but then you also have to think about operation and maintenance costs, meaning changing those filters out over the years, which could run into the 6 figures each month. Continuing on with the estimated cost of compliance, I'm sorry, we just talked about that. Who's responsible for this? Well, throughout our litigation over the past 5 years, 6 years, we've identified these corporations that are potentially responsible parties. And thus, these are all part of what's been called the multi-district litigation, or the MDL. And MDL can only happen in a federal court. And so class actions can be filed in a state court or a federal court, but multi-district litigations, meaning if you're filing against these same defendants in Wisconsin and the same defendants in North Dakota and the same defendants in Minnesota, they will eventually all be converted into a multi-district litigation panel. And a panel was formed here and then assigned to a judge in South Carolina, Judge Richard Gergel. These are the defendants. These are the manufacturers. On the left side, 3M, the largest producer of PFOS, and you can see down along the line on the left side, DuPont there, and then on the right side, those are the manufacturers. On the right side, continuing on with the various PFAS manufacturers and the specific manufacturers that manufactured firefighting foam. Think Peshtigo, Marinette. So how did we get here? This is how we got here. I'm not going to go through every date here, but what I'm going to call to your attention is when we started this in December of 2018 and where we are basically now. If you look at June 22 and June 30th, those dates are important. So your first takeaway from this webinar is to remember those dates. June 22nd, it has for 3M settlement, it has meaning to it and it will apply to you. And June 30th of 2023, again, that's the DuPont settlement, the date that that was resolved amongst the attorneys and the corporation's attorneys. On August 22nd, the court approved the DuPont settlement, preliminary approval, and on August 29th, the court granted preliminary approval. And what that means now is a court, Judge Gergel, has approved preliminarily a notice to be given. So that's why all of you received a notice, and a claims administrator was assigned by the court, and everyone, a public water system across the United States, received a notice in September. And these dates that you see here of June 22nd and June 30th are very relevant and were contained in that notice. This is the timeline of how we got here, and we'll go to the next slide now. Throughout the litigation, we were always concerned. Did we want $100 billion from the parties involved here? Of course, we would like more money than we were able to negotiate with them. But what always loomed, either in or outside of that courtroom, we're always concerned the court, and we're concerned all the parties involved here, was bankruptcy. Bankruptcy is always a possibility in any large-scale litigation. This is a very large, complex litigation against those manufacturers of PFAS and those manufacturers of AFFF foam. One of them did, in fact, file for bankruptcy protection. Kitty filed for bankruptcy earlier this year. Kitty is a named defendant in this litigation, filed for bankruptcy to address its liabilities directly correlated to this matter. This is exactly what we want to prevent from happening to other large, big defendants, such as 3M. Nobody wins if the defendant files for bankruptcy. So what are the claims? What are we talking about here? What are we being asked to release here? Well, if you go to the claims, there are many. And this slide here doesn't talk about personal injury claims as well. There are many Americans who are sick with a certain particular testicular cancer, a thyroid disease, or a certain ulcerative colitis. There are illnesses in a personal injury action that are also involved in this type of litigation, or in this what's called this MDL that I spoke about. But we're talking about public water systems only today. When we're talking about these two settlements, we're talking about public water systems only. We're not talking about real property that's owned or damaged by a local government, a city, a town, county, like your wastewater treatment plant. We're not talking about that either. We're not talking about other potable water. We're talking about public water systems only. This slide shows the different types of claims: public water systems, real property, wastewater, stormwater, airports, personal injury. The claims that we're talking about today are only those related to a public water system's drinking water. In other words, water intended for human consumption. All other claims remain viable. And local governments that are on with us today certainly own those other assets, such as wastewater treatment, a landfill, or an airport, or a fire training center. So, as I mentioned before, let's start to unpack DuPont. All public water systems, again, should have received a notice by now of these settlements. Here, this slide is talking about DuPont. And you can see the dates here. In litigation, dates are important. The court has a schedule. The claims administrator has a schedule. We're all on notice now. September 5th was the notice of the settlement that was sent out. You can see the various dates here. December 4th for objections. The court wants to hear from public water systems if there's issues, problems, questions, or concerns that they want to object to, or request for exclusions. That would all go in, and the court has a schedule when it will issue a final fairness hearing, And you could see that schedule for the 14th of December, and then the schedule of how the court will approve if it chooses to approve, a date of final judgment, and then a phase one public water system. And we'll talk about that in a minute. What is a phase one system? Has certain days to submit their claims. Phase one, just think about, again, as we go through this, it's going to be a little complex, but just think about phase one. Hey, I got a detect. I have a PFAS detect as of a certain date. And if you have that detect as of that certain date, you are now a phase one claimant. If you're an eligible water system, under these two settlements, and we'll unpack them each. If you're a phase one system, you would be eligible for payment under what's called an action fund, and we'll get into that in a minute. But phase one and phase two, we'll unpack each of those phases. This webinar, again, designed to further inform you as to the terms and conditions of both settlements. On 3M, there are slightly different dates. If you looked at the prior slide, and we will get these slides distributed to you as well, you could see the different dates that are the notice of settlement is a little different. The schedule of approving that final order. The court, again, has notified all eligible public water systems in September. In the case of 3M, the notice of settlement went out on the 12th of September, and objections and requests for exclusions need to be made no less than 60 days after notice is issued. And so this is, again, that schedule for the public water systems to be interacting with 3M settlement. 3M settlement is a much larger settlement, and we'll unpack that in a minute because of the amount of the chemical that it put into commerce versus DuPont. And that's why the DuPont settlement is much smaller than the 3M settlement. But putting these settlements into context, the 3M settlement is a result of 4 years of intense litigation, complex negotiations. To put it in context, this 3M settlement is the largest water contamination settlement in the history of the United States. It represents nearly a quarter of 3M's total value, 22%. I want to highlight that collectively the settlements would be the largest source of PFAS funding made available to water suppliers to date, and again, only releasing public water suppliers' claims for treatment and remediation costs, not real property. But remember, many other funding sources are needed. Think federal grants, and I know the state of Wisconsin just distributed a large amount of state grants, state water grants, federal water grants. I would encourage everyone with a PFAS contamination to consider and pursue all of the above, not just the settlements here from 3M and DuPont and the other outstanding defendants, which are still part of the litigation, but there are federal grants, state grants, and of course our ratepayers and other defendants are the sources of funding that will be needed to attack this contamination. Let's compare the two settlements. This chart, again, we're putting a lot out there, but there's an awful lot to unpack out of the settlement here. This is the comparison between 3M and DuPont. So on the left side, let's talk about the main differences. Their value, again, you can see 3M. Why? Because they manufactured all of PFOS in the United States, and they're the largest producer of that. DuPont, a much smaller producer of these particular type of chemicals. So you can see the value of the individual settlements. The 3M settlement has exclusions that are different. Look at that second bullet here. One of the key takeaways here from this webinar here is to understand this. 3M excludes non-transient, non-community water systems serving less than, that should be less than, not greater than, less than 3,300 customers, and all transient non-community water systems. On the other hand, DuPont settlement includes all non-transient, non-community water systems and transient non-community water systems. So right away, there is some information that differs between DuPont and 3M. 3M excludes smaller systems, DuPont doesn't. 3M settlement provides phase two. Remember what phase one was. As of a certain date in June of 2023, your system had a detect. Phase two means as of a certain date, you did not have a detect, which is involving most of you on this call here today who have not had a PFAS detect yet. But the 3M settlement here provides phase two, meaning those without a detect yet, up to $800 per water source for testing. It's important that we establish baseline testing as part of these settlements, and we'll get into that in a minute. DuPont, $200 per water source. So 3M giving much more funding for testing, DuPont giving $200 per water source. In the 3M settlement, baseline testing samples can be taken from either raw or treated water. DuPont needs to be taken from raw water only. So again, baseline testing samples, the methodology differs between 3M and DuPont, and we have some recommendations, which I'll go over with in a minute on that. In 3M, phase one, remember, those with a detect do not need to perform baseline testing on water sources that were already tested after January 1st of 2019. And in DuPont, phase one, meaning you had a detect, members do not need to perform baseline testing on water sources tested after December 7th of 2021. And we'll talk a little bit more about baseline testing in a minute. Finally, DuPont provides small compensation to very small water systems and also on inactive, impacted water sources. And again, 3M does not provide those two small payments to small systems. Who's part of the proposed settlement? What is an eligible entity? As you are filling out your claims and submitting them to the claims administrator, you have to understand what type of system are you? Who is eligible for the different settlements? In the DuPont settlement, a couple of observations. On the right-hand side, all public water systems, that's all of you, as of June 30th, 2023, had a detect. So in the DuPont settlement, an eligible entity is any public water system as of June 30th, 2023, who had a detect. And then the second bucket here is any public water system under DuPont as of June 30th. Again, remember these dates of June 30th is either subject to monitoring rules of UCMR 5, in other words, large systems serving more than 10,000 people, and small systems serving between 3,300 and 10,000 people, or any system that is required under any state law, which you are not, or federal law, which you are not yet required to test for PFAS before the UCMR 5 deadline. So in DuPont, those are the criteria there, the eligibility. In 3M, let's look at their terms. In 3M, an eligible entity is any public water system, meaning any of you that had a detect as of June 30th. Again, June 30th for 3M, June 23rd for DuPont, or June 22nd, I'm sorry, for 3M, and June 30th for DuPont. So under 3M, anybody that had a detect as of June 22nd, or any public water system that did not have a detect as of certain that date of June 22nd of 2023, and is required to test for certain PFAS under UCMR 5, or serves more than 3,300 people. So 3M, if you look at that bottom left side here, really addressing systems that serve more than 3,300 people as defined under the federal SID list. Systems under 3,300 people under 3M are excluded. So let's talk about the exclusions. It's important to understand, again, which systems are eligible. Who is excluded? On the right side, under DuPont, in the DuPont settlement, the exclusion is any public water system owned or operated by the state of Wisconsin, or any federal land water systems that are owned by the federal government in Wisconsin. Those are exempt. They are not eligible. They are excluded from the DuPont settlement. Importantly, we get lots of questions Well, what about the private well owners? Any private well owner, well or surface water system privately owned is excluded under DuPont. And you may be receiving lots of questions about private well owners around your municipality. They are excluded from DuPont. Under the 3M settlement, the entities that are excluded are, again, remember, the non-transient, non-community water systems serving 3,300 people or fewer, or number two, transient non-community water systems of any size are excluded. And there and again is that exclusion for anything owned by the state of Wisconsin or the federal government is excluded. And again, any privately owned well that provides water only to its owner or to its owner's tenants, individual households, are excluded. No private wells. The allocation procedures were an intense negotiation. There was a lot of mathematics that was used, a lot of scientific studies, a lot of very bright people were brought in to carefully negotiate and craft a fair and equitable settlement that needed to be approved by the court to allocate any settlement funds. When you have $15 billion, how do you distribute them around the United States in a fair and equitable manner? So the other second key takeaway about this webinar here today is, well, how are the allocation procedures? Will they affect my municipality? I saw earlier in one of the chat, do we have a published set of data on flow rates? No, we do not have that for the state of Wisconsin. It's not something that is published by the state of Wisconsin, DNR, or the federal government. That is a unique proprietary information unique to each individual system. So only you know your flow rate, and only you know your contamination testing information. So it's the combination of those two that are the most important factors in calculating what's called a PFAS score. So the two main factors in calculating the cost of treating PFAS coming out of these settlements, these are the two factors that were used to come up with an allocation model. They were taken into consideration to include the volume of the contaminant water, what's called the flow rate, and the degree of the contamination. And this applies to each individual impacted well. Also, these allocation procedures use scientific EPA-derived formulas to arrive at allocated amounts that proportionally compensate qualifying settlement class members for PFAS-related treatment. This was important to all parties, defendants, as well as the attorneys who brought these actions on behalf of the public water systems. So again, your PFAS contamination concentration plus your flow rate gives you a PFAS score. So how does a municipality participate in this? There's a claims form process. The claims form administrator is going to be, there's a claims form website that you will learn about in a minute. You would go on this website and you would identify yourself as what type of public water systems you are, and then you would begin to submit your claims forms. The claims administrator is going to verify that you are who you say you are, and you are, in fact, a phase one qualifying class member. And remember what we said about phase one? That's a system who had a defect as of a certain date and time, and a phase two is everybody else that didn't have a defect as of a certain period of time. You either fall into either phase one, or phase two, plus being a qualified public water system. The settlement categories, again, unpacking DuPont and 3M. Apologize about the amount of information that we are giving right now, but this is all we have coming out of the settlement. It's very complicated, but we need to go over it. This is what the court asked us to do around the United States. So DuPont, let me explain the categories for each of the settlements. And again, keep asking those questions in the chat and we'll answer them as we can throughout the webinar. In DuPont, the allocation procedures. A phase one, remember, has a detect, is a public water system that collects water from any water source that tested before June 30th, 2023, and was found to contain any PFAS at any level. Any level, any detect, tested before June 30th in DuPont becomes a phase one member. Remember, phase one, you can seek funding for that detect through the allocation procedures we talked about. Phase 2, under DuPont, anybody that has not had a detect, phase 2 member is a public water system that is subject to the monitoring rules set forth in UCMR 5 or other law. Under the settlement categories for 3M. In 3M settlement, a phase 1 qualifying class member is an active public water system that has one or more impacted water sources as of June 22nd, 2023. So under 3M, to be phase 1, meaning you had a detect as of June 22nd of this year, and a phase 2 qualifying class member is any public water system that did not have any detect as of June 22nd, 2023, and is required to test for certain PFAS under UCMR 5 or serves more than 3,300 people. And again, there's that phase 2 qualifying member under 3M, no detect as of June 22nd, 2023, which is largely the vast majority of you. You have not had a detect as of June 22nd, 2023, and is required to test for PFAS under UCMR 5 or serves more than 3,000 people. Those are the categories for DuPont and 3M. An overview of the funding. If you think about DuPont, the vast majority of this chart here, an action fund, a very small system payment, an inactive system payment, transient non-community water system payment, non-transient non-community water system payment, special needs and supplemental funds, that's DuPont. So if you think about it, DuPont had 2 extra buckets here, very small systems and inactive system payments, DuPont. The rest applies to 3M and DuPont. So let's unpack it a little bit. I won't spend too much time on the DuPont payment for the very small public water system payments, but I'll say that certain water systems, this relates to the transient non-community water systems and the non-transient non-community water systems serving less than 3,300 people. DuPont has set aside $1,250 and $1,750 for those very small public water system payments. DuPont also, as I mentioned, had a small payment for an inactive impacted water system payment. This fund is for qualifying public water systems that are classified in CIDWIS as inactive. They would get a one-time payment of $500. Under the DuPont settlement, there's something called an action fund. That's at the top of this. And the action fund applies both to DuPont and 3M. But under DuPont, this is the amount of money that the public water system will receive after you run your PFAS score. Remember, to develop a PFAS score, it's the maximum amount of your contamination and divided by your flow rate. So your flow rate and your contamination levels produce a PFAS score, and that translates into an action fund payment. The other 2 buckets under DuPont are what's called a supplemental fund. This fund in a supplemental fund is used to compensate water systems that have an impacted water source that do not exceed a state MCL or any proposed federal MCL at the time the claims form was submitted, and because of later PFAS testing, does get a higher test result. There's a supplemental fund that's set up to draw down. It also is for public water systems with impacted water sources that do not exceed an MCL at the state level or a proposed PFAS MCL level at the time the claims form is submitted, but later exceeds a future state or federal PFAS MCL. These systems have until December 30th of 2030. So running through the rest of the decade, this supplemental fund is set up to provide funding for systems that have a defect at a later point in time. In situations like the city of Wausau, a special needs fund is set up. Wausau has spent quite a bit of funding from its own sources, from its own ratepayers, and from the state and federal grants to address situations where the system spent money to address a PFAS contamination. As a special needs fund that's set up under DuPont for the city to draw down on as a participating entity. For 3M, just as the DuPont settlement allocation procedures I just went over, for phase 1 and phase 2 qualifying members, they can draw from different buckets. 3M only has 3. Think action fund. Think I have a DTEC as of June 22nd of this year. I can apply to that action fund with my PFAS score, my flow rate, and I'll get a payment coming out of the action fund. Think supplemental fund. Same thing that we discussed under DuPont. A supplemental fund is stood up for a period of time for the rest of the decade. If you do have a system detect in the future, you can apply for funding out of the supplemental fund. That was called an equalizer clause in the negotiation, so that systems who had the detect and who were fortunate enough to have been testing were able to draw on an action fund, and those that were not in that situation would have a chance to draw down funding, and that's why the supplemental fund was put in place. Again, there's that special needs fund is in place in both 3M and in DuPont. The difference again is DuPont has those extra 2 buckets for small systems. So talking a little bit about this slide just shows you how an average score is put together. A lot of math going into this to calculate your PFAS score for each impacted water source. Using Wausau again, 6 wells, 6 contamination in each individual well. Each of those individual wells would develop its own PFAS score. So if you just think, select the higher of the maximum contamination of those 2 contaminants there. So if you had to detect the PFOA and PFOS, you would use the maximum level. And then there's also another equalizer here in situations in local governments and districts which had a different PFAS contaminant that was detected, PFNA or another type of PFAS which the DNR may have regulated, or one of any other 29 PFAS chemicals. You could use those as well. So even if you didn't have PFOA or PFOS, this allows you to use any of the other PFAS listed on the claims form to develop a PFAS score. Claims administrator is going to calculate your flow rate, highest annual average flow rate over a certain period of time, 2013 to 2022. So once you have your PFAS score, then your flow rate, the claims administrator is going to calculate your flow rate, which is the highest annual average flow rate from 2013 to 2022. This average will then be averaged with your maximum contamination, thus producing a claims score. After that is all developed, the PFAS score is developed, submitted by the entity, either through council or through the water system directly. The claims administrator then is going to go through a series of additional adjustments, they're called. So the adjusted base score is developed through these entities. If you were involved in the litigation up to a certain period of time, you would get an adjustment, more funding because you were a litigant. If you were part of the initial class of 10 who brought these lawsuits in a representative capacity of all the other water systems around the United States, you would get an adjustment. If you were complying with a state MCL, which is not the case in Wisconsin, you would have a regulatory adjustment because your state had regulated this field. And so there are 3 adjustments. The calculation of these adjustments is on top of your adjusted base score and will be done by the claims administrator. So another third piece here of a takeaway that I like to say here about the different things, remember those dates. Remember, phase 1 is I had a detect as of June 30th, or I had a detect as of June 22nd. Those are 2 key takeaways from this webinar, from these settlements. The other one here, in my mind, really is the baseline testing. Phase 1 here, in order to participate in these settlements, remember, public water systems have to have tested or have to test now. And there are differences in the testing methodology. Public water systems need to perform what's called baseline testing. The companies require a baseline so that everybody knows what was in the drinking water or not in the drinking water as of a certain date. But in order to participate in the settlements, the systems need to perform baseline testing Water systems must test every water source, groundwater well, or surface water system that they own for PFAS. The DuPont settlement requires the public water system to test for raw water. 3M, remember, gives you the option to test for raw or treated. So our recommendation to you is that if you've not tested at this time, you need to test your raw water so that you're following both settlements. Again, if not tested, test your raw water so that you can comply with both settlements. A note, baseline testing is different under these settlements than from what the United States EPA requires if you're in conformance with UCMR 5. Because under UCMR 5, a public water system is required to test for PFAS only at the entry points to its distribution system. The settlements require different testing protocol. Baseline testing under the settlements require a test of every source for at least 29 PFAS chemicals under UCMR 5. You need to produce all the analytical results, including actual numerical values, to the claims administrator and submit the results to the claims administrator. So settlement terms different for baseline testing than the US EPR. Again, both the companies and the plaintiff's attorneys, the water attorneys, required a baseline so everybody knew what the baseline results were as of a particular date. Baseline testing, very important in these settlements. However, if your public water system has previously performed testing on your water sources, you may qualify for an exemption and you would not need to do further testing. Let's talk about 3M first. Any water source that was tested before, again, that date, June 22nd, 2023, the date of the settlement, under 3M, any water source that was tested that had a detect does not need to be tested again for purposes of establishing a baseline testing. And any water source that was tested between January of 2019 and June 22nd, again, the date of that settlement, and did not find any measurable defect, you do not need to test again. So if you tested between January of 19 and June 22nd, 2023 with no defect, you don't need to do additional baseline testing to participate as a phase 2 or a phase 1 eligible entity. Under DuPont, here's that date again. Any water source that was tested on or before June 30th. Remember, think DuPont, June 30th, 3M, June 22nd. Under DuPont, any water source tested on or before June 30th that was found to contain PFAS does not need to test again, that water source again. And again, any water source that was tested between some differences here, December 7th of 2021, so 2 years later, and June 30th of 2023 with no detect, you do not need to test again. So there are some exceptions to establishing baseline testing if you have tested in the past. This slide shows you those important dates. Record keeping essential. You'll need to get the testing results, have all that stuff, and submit it to the claims administrator. During the negotiations, it came to our attention that testing could be expensive. We tried to do everything we can, working with the parties, to find a testing lab that can assist systems who may not have ability or access to it. If you are an entity that needs assistance in testing, Eurofin's lab here has been contracted to do that, or they have agreed to do a discounted testing program. Here's their phone number, here's their email, and again, there's a website that's created for this specific matter. You can see that website there to access it. However, you do not need to use Eurofins, of course. You could use any entity that you want, as long as they're EPA approved lab to perform your baseline testing. Let's talk about that allocation table. Let's talk about that PFAS score and that flow rate. And here's a chart. When we were before Judge Gergel, we had to explain to him. He asked, well, give me an example. How would this impact a small system with a small flow rate or a large system with a large detect? So here is a chart, very important. Adjusting that flow rate, gallons per minute. On the left side there, the PFAS score. So you could see on this chart here, let's take an example. A column on the left with a PFAS score of 10 and a flow rate of 100. That would give that public water system, that well, $148,000, $252, $148,252 per contaminated well. So again, knowing your PFAS score, your adjusted PFAS score, and your adjusted flow rate, again, that 8-year window of getting an adjusted flow rate, the highest average flow rate gives you ranges here. So if you hit 5,000 an adjusted flow rate with a PFAS score of 10 found it in your system, 2.4 million. And so you could see the adjusted amounts that are used here. This chart used to give you a measure of what your system would be eligible for. If you see massive contamination on the down on that left side there of 750 with a large flow rate of $50,000, that system would get $40 million in this settlement. Claims form, the process for claims form. Again, the takeaways here, am I a phase 1 system? Think Wausau, who has documented contamination, or Racine, who's not had a documented, that would be a phase 2 system. Or I think Racine did have a DTEC, so it would be a phase 1 system. But if you're a system that has not had a DTEC, think phase 2. If you had a DTEC, you are phase 1. So the initial step for establishing eligibility for compensation is to complete a claimant information form. After a person completes this claims form, the water system provides additional relevant claims forms for the payment sources. Water utilities can register and submit this directly or use an attorney on their behalf. Opting out. The judge talked a lot about opting out. It's an opt-out settlement. If you choose to do nothing with these settlements, you have made a choice, and not a good one. If you choose to do, you should choose to do something. If you're going to opt in, follow the claim form instructions because it matters. If you choose to do nothing, you have precluded your municipality from doing something in the future. If you choose to opt out, what happens if you opt out? What are the effects of opting out of a settlement? One, the water system is off the fast track to get funding. The water system faces potentially years and years of litigation following personal injury. Remember what we talked about earlier on? Personal injury claims by firefighters who may have been developed a cancer, or other emergency responders or airport workers who were exposed to the contaminant. There are personal injury claims. There are going to be wastewater treatment claims. There are going to be airport claims, military-based claims, state attorney general claims. If you opt out of this, you are going to be put in the back of those other cases that will be ahead of you. The defendants will conduct a full discovery in each individual case. The water system will not receive any funds to correspond to any compliance efforts that are coming from the United States EPA as they impose an MCL on PFOA and PFOS. So these settlements were designed to provide funding at the same time the United States was overlaying an MCL. Finally, if enough public water systems opt out, the settlement fails. The public water systems receive no funds at this time, and again, risk bankruptcy. So the enemy of the good is perfect. And that was Judge Richard Gergel, who we mentioned during the hearings and throughout the process here. It's a very complex litigation. This was the best that we could do in light of the circumstances that we were facing. Most important matter related to these settlements is that it addresses the most prevalent source of PFAS contamination in humans, which is in the drinking water. Thus, these two settlements are bringing a resolution for claims that mostly directly bear on human health and safety. I want to say thank you. I know that this was a lot of information to put out in a 1-hour time. We're approaching that last period of time here. I know quite a bit of this was presented to you today. A lot of information. This is our contact information here that you could see on here. Any one of us you could send an email to. We will respond to that. You can also send it to the league and they will get back to you. We will be working with the league on questions and answers. But again, I know a lot of information put out today. The court has requested this information be provided to the local governments around the United States as broadly as possible. Notice was sent to all public water systems by the court. This is an opt-out settlement. Again, so if your system does nothing, they will miss out on a potential funding in the future. And again, to preserve your seat here or your eligibility, baseline testing, very important for you to secure your funding. And remember to test raw water. The last thing I want to just say before I turn it over to Coral for closing remarks and then to Liz is which claims are being released and which are not. The following claims are being released under 3M. Claims related to a public water system's drinking water. Think water intended for human consumption. Why do they want to release? Because they are putting up that amount of billions of dollars, 13 billion. They needed closure. They are facing multiple aspects of litigation beyond drinking water, so they had to bring closure for the drinking water systems. Also, any representations about PFAS are released and punitive damages for all claim types are released. The following claims are preserved, assuming the following criteria below is met. Real property is preserved. Claims related to remediation, testing, monitoring, or treatment to remove PFAS from the real property are preserved. If that real property is owned by the class member, if the real property is separate from the public water system, think airport or fire training system, and the class member seeks damages that are unrelated to drinking water. So real property exceptions, those claims are preserved. The claims relate to groundwater under real property. The class member must either identify another potable water system aside from the public water system that may be affected or be subject to a state or federal directive, order, or permit condition not premised on protecting the class's public water system. For example, if you assert groundwater remediation as the basis of your damages and the groundwater is used for public drinking water, that damage claim is not viable because it was released. This is because that claim is considered under the settlement agreement to be one and the same as the public water system that is already being compensated, and that essentially avoids a double recovery. However, the identification of another potable water source at risk or a state or federal order not premised on the public water system is not released. Wastewater, stormwater exceptions. Claims related to discharge, remediation, testing, monitoring, treatment, or processing of PFAS at a wastewater treatment or a stormwater system are preserved. Where the class member owns that system, the facility is not related to the public water system, and the class member is seeking damages unrelated to drinking water. So I wanted to raise those because I know the league had referenced that ahead of this webinar. So I will stop there. Coral, turn it over to you for closing remarks, and thank you all for your attention.
Thank you, Steve. And we want to thank the league. We're coming up to an hour here, so we want to wrap it up. We thank the league for giving us the opportunity of presenting to all of you about these important settlements. I know there are a lot of questions. Our associate Veronica Vasquez has been responding to those questions in the chat. We will get a printout of that chat and we will be responding to those questions in writing so that we can send to all of you those responses. If you have any other questions there that you have not submitted in the chat, there are our emails here in the slide. You can contact any one of us and we will gladly respond that question via email. Again, thank you so much to the league for letting us be part of this settlement, of this webinar.